Welcome everyone. So today we'll be having an administrative law introductory class. So Canadian administrative law. So this in this introductory class we have to understand how the question will come and how the syllabus is to be understand. We have to understand the particular syllabus. If you will go through the syllabus of administrative law, it explains many things in the particular syllabus aspect, but very important or key to pass administrative law is that there should be streamlining of that syllabus. That means there is a step-by-step analysis that has to be done. So that means if the question is being asked to you, that particular question has to be understood based on the statutes that has been provided to you or the powers which are being given by the statute to the administrative body, administrative decision maker, and then analyzing the step-by-step approach based on steps. That analysis is to be done, that whether there is any breach of rule of law or infringement of rule of law by an administrative decision maker or not. So that is what we have to understand, that administrative decision maker or that public decision maker, whoever that is, fine, that whether he has acted in accordance with rule of law or not. So this is what we have to analyze, that whether that particular decision maker, he might be getting power. If the question is in very much detail, then you will be also provided with certain statutory statutes provision. Let's say it is, take an example, immigration minister has given some decision, so they will provide you with the particular sections of that particular statute from which he is getting power, which he is getting discretion. So that aspect we have to also analyze. So here if we will see, if this is initial aspect that we have to understand, but how to understand administrative law. So first of all, if we will see, administrative law is what is if we want to explain, or let's say if you want to understand administrative law, then it is, we can say, a body of law which regulates the way executive, we can say executive, as we see in our constitution law or in our foundations law, we have understood in a way that or there is a doctrine of separation of power that is present in Canada, no, though not in that strict sense, and it is not specifically mentioned in any of the provision of the constitution, but still we find that that is an underlying principle on which the Canadian law stands. So that is separation of power, that is separation between executive, separation between judiciary, separation of legislation. Fine. So we will see that there is in a government there are three bodies, so those work separately. They have their own sphere of power, we can say, or they have their own functions to perform. So one is legislation, which makes law. Legislation and executive, they are, as we have seen, that they are intertwined in such a way that we can see that they are actually influencing each other. When a legislation makes a law, that gives power to an executive to perform that particular law, or we can say to enforce that particular law. So when that particular law is being enforced by an executive, then those executive, let's say ministers, those ministers, when they are in parliament, they make law. That how they make a policy, they make a legislation, and they grant power to a executive that they should make regulations or policies with regard to those legislation that has certain purpose or objective. To achieve that objective, to achieve that purpose, they have to draw some policies and they have to work within those policies. So that means those powers which are being granted by that statute to an executive, they have to perform. So when we look into administrative law is a body of law, that body of law which regulates the way the executive and government operates. Executive we can say, or government we can say, that operates. And how they have to operate, that it is understood as that it has to act, it has to operate within the periphery of rule of law. Within rule of law. So this is what we have to understand in administrative law. It is, we can say, a subset of constitution law. So it is a subset of constitution law. That is what we have to understand. So in constitution we have also seen, if we have already read constitution law, Canadian constitution law, or otherwise also we understand that there is a judicial review. So that is what we have to do whenever there is a question or whenever there is an issue with relation to constitution, judicial review of that particular legislation. So in constitution law we have read that there is a particular legislation, and that legislation is to be analyzed, judicially reviewed, that whether that law is valid or invalid. So that is what we have done. We have Oakes test, we have division of power. So that we have done in our constitution law exam. Though we will be doing, if you have not done, many of you must have not done that constitution till now. But when you will do that, you will understand that that aspect is judicial review with respect to legislation, or we can say legislative action. When legislation has made certain law, now they have to also make such law which are within the provisions of the constitution. So that means it should not be inconsistent with the constitutional provisions. So that is section 52. We have understood that section 52 is very important section in that regard. Now what we are understanding here is, a subset of constitution law. As I have told you in the very beginning, that executive and government legislation is intertwined. When we say intertwined, when we say they are intermingled, we can say that minister plays a dual role. When we are saying dual role, one, the role is of legislator. We can say when he legislate a particular act, legislate a particular law. And on the other hand, when he is enforcing that law which has been legislated, which has been made by a parliament or by a provincial legislation, that has been made and now they are enforcing it. So as an enforcer of that particular law, as an enforcement body of that particular law, they perform as an executive. So while making the same law, they perform as an legislator, they perform as an MPs. Fine. So that is what we have to understand. But here if you will see that aspect, as I was telling you, that here we are talking of when an executive is performing, then he has to perform within rule of law. As we have read the case Ron Kellery, fine, of course if you have not read right now, though don't worry. So there they have said that there is no untrammeled power that can be given, and then we have judicial review power, as we have seen Black case, fine, Black Canada case, or when we see Operation Dismantle. So they are saying that we can, if there is any legitimate expectation or any charter right is breached, then of course court have jurisdiction, or we can say doctrine of justiciability. So they have justiciability to look into that particular matter. Now how the things are to be understood here in administrative law? First of all, as I have told you right now, that it is a subset of constitution law. Here also we are doing a judicial review. A question will be given to you where an administrative body will be getting a particular power, or will be having a power, or a power is granted by a statute. So there are administrative body if is exercising a power, or making or giving a decision, or haven't made a decision, or has given a decision against any individual. Now that individual has approached you, but saying that this particular decision has been impacting me, or there is a decision which is made against me by an administrative body. Fine. So that decision, that particular question which is being posed to you, the facts of that question we have to understand. Fine. We have to read the statutory provision that is being provided to us, and then we have to understand that question, and then going further decide about it, whether the administrative body or that particular decision maker's decision is valid or invalid. Fine. Or that particular decision can stand or cannot stand. That means that whether the court, after analyzing the decision, will find that there are certain shortcomings, there are certain issues which do not stand alongside with rule of law. So that means they are not as rule of law would require to be. So understanding that aspect, if you will see. So here, if we will see this constitution law, or we can say this judicial review, places a constraint on the limit of executive power. So when I am saying executive means there are different executive. We can say minister is an executive, crown is an executive, fine. Cabinet is an executive, government departments are executive, fine. Municipal corporations are executive, administrative tribunals are executive. So when a decision is made by administrative tribunal, they are also executive, fine. Or any agency which is carrying out a government function, they are executive. Any agency. So this is, we can say, this is a residuary thing. So in residuary, if we will understand that any agency will be considered as an executive. So how the question will come, that this particular agency, let's say take an example, labor minister, fine, arbitrator. An arbitrator has given this particular decision, or he has given this interpretation of the provision of the statute through which they are getting power, or when a collective agreement is to be given. When a collective agreement is to be given some interpretation, so arbitrator has given such interpretation. In this way, they have given interpretation. It can be Minister of Immigration. It can be any minister. It can be labor minister. It can be transport minister. It can be any transport agency that has been working working as a government functionary. Fine. So anyone of such kind have given some decision which is impacting on some person. So that person has approached you. Now you have to analyze that in that particular question that has been kept in front of you, that what all things are what we have to look in. If they are present, then of course the decision will stand. If they are not present, the decision will be quashed and it will be sent back to, the decision maker, or sometimes, very much rarely, fine, it is very much rare, but court themselves can decide. But court generally remit it back to the decision maker. Okay, looking into the taking help of the decision or ideas that has been given by the court, that how you should proceed, what are the shortcomings in the particular decision, looking into that, and then consider again. Although after analyzing that, same result would come, but still court will say that you have to follow this particular, let's say if there is a procedural issue, then procedure. If there is a substantive issue, then the substance, whether you have lagged in substance, whether you have lagged in procedure aspect. So that is what we have to understand. Is that clear till now? So going further, if we will see, first of all we have to analyze how the question will come and then how we have to answer that. So here also we have 4 things to be looked upon in our answer. So that is table approach, as I have coined it, or I have said many times, that we have to support our answer by 4 legs, fine, or 4 columns. So first of all, analyzing the issue is key. So first of all, what legal issues are there? So there will be multiple legal issues in one question. So those legal issues are to be looked upon one by one. We will be checking those legal issues. Now when I am saying one by one, that means it requires a step-by-step analysis. So that is the second leg that we have to support our answer with. So it will be always step-by-step analysis. There are different stages. Based on those stages or based on those steps, we have to analyze the facts which are given to us and applying those with the rules. So that step-by-step approach is what we will be taking. Then third is the rule, which is there. Fine. So we have to mention, we have to analyze the rule here. And then further, the fourth one is application. So applying those things with the rule. Applying the facts scenario given to you with the rule. What will be your decision? Why you are saying that, if you are saying that this procedure is not followed, let's say, then what are the requirements? So that is what we will be analyzing. So here if we will see, the rules are common law rules. So that we have to understand. So in NCAs, as I have told you in my earlier classes, or let's say if those who have not earlier was not with me. So as NCA actually test your understanding of common law. So that is what we have to understand. So here also it is common law that we have to, how common law will come into play. So whenever, as we also know that common law, whenever there is an inconsistency between common law and statute, it will be statute which will prevail. So that is also there. But here they will be mentioning, they will be looking into the understanding of common law. So that means if some procedure is not followed, as is procedural fairness doctrine or principle, we can say, that has been triggered, or that has been that has been laid down by Canadian courts, that has to be seen. So the Supreme Court have laid down that particular understanding. Otherwise, if we will see with respect to procedural fairness, principle of natural justice are there, but principle of it has been broadened by principle of natural justice are broadened by procedural fairness. So they are there. Principle of natural justice, if we will see, there are three principles of natural justice. That is, one, audi altum partem. That means everyone should be given right to be heard, or we can say straightforward, right to heard. Right to be heard. Then nemo judex in causa sua. That is, when we see that no one can be judged of his own cause. Or we can say that impartial decision maker should be there. Rule against biasness. And third, reasoned decision. So there should be a reason should be there for every decision. So reasoned decision should be there. So these are there. Then these all are expanded, or they have been widened by the principle, we can say, of procedural fairness. So we have to understand procedural fairness. So that is one aspect of the question. Fine. Then another aspect is the question. I'll explain you how the question comes later. But another aspect, if you will see, that is substantive constraint. So when we understand substantive constraint, when we say substantive, as the name suggests, substantive, that means any right, fine, which may be infringed because of any error of fact, error of law, fine, or by applying any discretion, by making certain interpretation which is wrong, which is bad interpretation. So such interpretation is given. So error of law is there, error of fact is there, substantive, your right has been infringed because of these errors. So not because of the procedure, but because of these legal error, this error of law, we can say, or error of, that means the decision is not on merit. Fine. So that is there. So if these are present, then we will go for substantive constraint. If there is a procedure issue, procedure means, let's say he was not given a chance to be heard, or he was not given a chance to submit his statement, or he was the decision maker was of closed mind, already he had certain stereotype in his attitude, so that has been shown from the fact to you in the question. So that means they are talking of procedural issues here. That procedure was not good. That means the biasness was there in the decision maker mind. And when there was a biasness, then the decision will also not be with a free, how the free decision maker would have given. keeping openness of mind, accepting the things. So that issue is there. That means there is a procedural issue. Fine. Right to be heard is triggered. Rule against biasness is triggered. So they are procedural issues. Then, as I have told you, substantive. In case of substantive review, when we understand substantive review, so there are two things that we have to look upon. So first thing is, which standard will apply. So when we talk of standard, that means which standard of review will apply. There are two standards now. In Dunsmuir, it was laid down two standards. Earlier there were three, but in Dunsmuir there were two, which is reasonableness and correctness, and that is being accepted by Vavilov as well. So in Vavilov, which is the latest case on substantive constraint, fine, and that is a landmark case where we can see that they have also accepted two standard of review, that is reasonableness, which allows deference, which give deference. That means judicial review is there. As I have told you in the beginning, there will be a judicial review. Judicial review of an administrative, just wait. Judicial review of administrative action. So when we say judicial review, so here judicial review, judiciary will or the court will look into when there is a substantive issue, then in that case court will look into which standard of review will apply. So that is the first thing that we have to do. The first step we can say, or we can say first step is availability of judicial review, that I will be explaining. Second step is which standard of review will apply. So that, as I want to tell you here, that one is reasonableness, where the deference is given by the court. Deference means that court will honor the decision of the decision maker. Reasonableness is the presumptive standard. Fine. So reasonableness, if you will see, is the presumptive standard. So that means it will be presumed by the court in all the cases that it is reasonableness. The deference will be given to the decision maker. However, there are certain rebuttals when this presumption can be rebutted. That we will be doing in detail in our regular classes when we will be understanding Vavilov. Fine. So there are two things. That one is institutional design, we can say, when the legislation wants that there should be correctness standard. And second is because of the rule of law. So that we will be understanding. So that means there in these two cases, it will be correctness review. That means correctness now means that court will say, no, we will not look into what you have seen, what you have given the decision. Will not at all look into that. We will decide because you were not allowed to decide in this fashion. Okay, court will say, I will decide. So that is court decides then. That is correctness review. Reasonableness, court say, okay, you have given the decision, we will give deference to it. We will give honor to it. We will look into this decision. Fine. If only when we can say that it is quashed, this particular decision is quashed, or this is to be remitted back, when there will be an unreasonableness in this, or the decision is unreasonable. Now that is a contextual analysis that we will be doing later. So as I was telling you, don't get confused right now. What I want to tell you here is that court will look into first stage with regard to that is that court will look into that whether which standard of review will apply. It is reasonableness or correctness. In detail we will be doing in our regular classes. So it is always reasonableness, that is presumptive. Court will give deference to the decision of the decision maker. On the other hand, there is correctness. Correctness will be only triggered when it is the legislation has intended so or rule of law requires. So that we will be understanding when rule of law requires, when the legislation has specifically intended for appeal. So that we will be understanding in our regular class. Then coming to after, when we are saying, let's say presumption is of reasonableness. So when the reasonableness is presumed by the court, we will further analyze whether the decision is reasonable or unreasonable. So we will look into certain fundamental flaws, whether they are present while deciding this particular case, whether an administrative body have done certain fundamental flaws. Fine. Their chain of analysis is lacking reasonability. Fine. They are not reasonable. Chain of analysis is not reasonable, whether that is there or not. Then there is contextual analysis, like governing statutory scheme. What actually statutory scheme is, whether they have complied with that. Fine. Whether they have complied with any principles, that may be common law principle, that can be international law principle, that can be statutory principle. So whether they have complied, they have given the interpretation within the statute or not. Fine. So these all things we will be understanding. There are 6 or there are 7 around, or 8 we can say. Contextual analysis, that is not exhaustive of course, but they are there. So that is what we will be looking into in our regular classes, how to go further, how we have to analyze. So that we will be doing it. Then coming to procedural aspect. Is that clear till now? So going to procedural aspect, procedural fairness, if you will see. So in procedural fairness, as the name suggests, procedure. There it was substance. Now it is procedure. So that means there is certain flaw. Now the person who has approached you, you will be in the exam, you will be given, you will be an articling student, or you will be working in a law firm or renowned law firm dealing with the administrative laws. Fine. So that will be your position in that particular question, and they will be asking from you that this is what the person has came up, and he has described his things, like whatever he has went through, he has been through in that particular decision which is being given against him. Now he will highlight many things in that. He will highlight about the procedure, we can say, they specifically with regarding to procedure when he is saying. Then we have to analyze the procedural fairness issue. When he is specifically targeting the substance, then we will be analyzing substantive review. So now as we are doing procedural fairness, so he will be in the question, there may be a question where both the things are triggered, both the things are there. So that will be a single question given to you, and that is how the question will be shown to you, and you have to do both the things, procedural as well as substantive. But let's concentrate right now on procedural. So here the person will come, he will say that he was not given notice. Something of this sort will be given to you, presented to you. He was not given disclosure. Fine. He was not given, he was asked that he will be, his statement will be taken, but no one came, no investigator did not turn up and did not actually took his statement. So these all things. Or he will say that one of the person who was linked with the particular investigation, he was also the decision maker. The investigator was a decision maker. So biasness issue he may raise. Or the person who has triggered the suit, triggered the particular complaint, he was related to someone, or he was actually the person who has decided the particular decision. So if these are the issues, biasness issues will be there. So these things we will be understanding in our regular classes in detail. Fine. So that means they are actually taking us towards procedural fairness. Okay, is that clear? So this is in brief we could understand about procedural fairness and substantive constraint. So if we will go further, how, as I have told you when I was explaining you about the step-by-step analysis. Fine. When I was explaining you about how to answer the question, how to support our answer. So first is issue, then rule, then application, and one of the thing was step-by-step analysis. So in both the cases, if you will see, whether it is procedural fairness or it is substantive constraint, first thing that we have to analyze is that whether there is a judicial review available. There is an availability of judicial review or not. So that is what we have to look upon. Whether the person who has approached you, whether he has right of judicial review that has been triggered or not. So our first step will be starting from there, analyzing the judicial review. So if you will look in here, I will send you notes, fine. And for those who will, like this is availability of judicial review. So my notes are like this only: issue, rule, application, and then conclusion. Fine, 1 line or 2 line conclusion you will find. So this is how my notes I have made. So we will be this is step 1. Whenever a question is to be started, we have to first analyze whether judicial review is available or not. So if there are certain, first issue is this particular page, if you will see, we have to write that this may carry a substantial amount of marks. Fine, or we can say if it is a 40 marks question, take an example, then it may carry 5 to 10 marks. Fine, so that is there. So this is how we have to analyze. So if we will look upon here, so this is first step that we have to understand. So availability of judicial review, whether judicial review is available or not. This is first thing that we have to determine. Now there are 5 questions that has to be answered in this particular analysis of availability of judicial review. So whether judicial review is available, we have to answer 5 questions in affirmative, in yes. So there, that is, if you will see, issue is whether judicial review is available against the decision of the decision maker of the order, whether that is available. The rule is, if you will see, those are 5 questions that we have to analyze. So first is whether the administrative decision maker a public body. So those who have understood, those who have read constitution law, they must be aware of entity test. So that test is of whether the decision maker, whether charter will apply or not, section 32. So there is an entity test. So that entity test tells us that whether the charter will apply, or here we will see that entity test will be applied. That is because the statutory body, because that particular decision maker is getting power from any statute. We have to mention that, we have to look into that they are getting power from a particular statute. That can be federal statute, that can be provincial statute. So when they are getting that power from a statute, that means they are government body, they are public body. So they are exercising those power because the government has given that power to perform. They have to perform in that fashion. So those powers are there. That's why it is administrative body will be considered as a government body or a public body. Hence judicial review is to be seen. Yes, the answer is yes. We have to find yes, this is a public body. Then going further, second, whether the applicant have standing to challenge the decision. So again, in my constitutional law classes, I tell you, or whenever those students who are present, they must be aware of that I explain standing there. So there is an IRAC of standing to analyze. So there is Downtown East Side sex worker case and Finlay case. So Finlay case laid down a test. In that test, we have to analyze 3 things to determine whether standing is there or not. So here also, not in that much detail, but we will be understanding, we will be explaining that it is if we will see, we have to understand that it is justifiable issue or not. That is first we have to look upon, and then whether the real stake is at issue or not. So that is when we will be analyzing, then that aspect we will be understanding. Then going further, the third issue, the third thing, third question, if we will see. So that is the court in which applicant should apply for judicial review. So in which court it will apply, he will apply. So if it is provincial, then we can go to superior court, or if it is federal, then federal court of appeal or federal courts, fine, if the legislation is federal. So that we have to analyze, we have to look in. So there we have to give in detail, we have to look in the details, and then we have to write accordingly. Then there is, does the deadline, or we can say whether any deadline has lapsed or not. So those deadlines which are there, which were there within the particular statute, they said this is within 10 days you have to go to the higher authority, and they went to higher authority, or that those deadlines are there or not. That is what we have to analyze. If yes, lapse, then we'll go further. Then last question that we have to answer here is, does the applicant have exhausted all other means of the recourse, or whether he has exhausted all other means. That means there was certain other means which were given. Okay, if appeal lies from here to this particular department, or you can go, the final decision will be of commissioner. So commissioner has decided it or not. That means the applicant has went to that particular thing or not. So this is how the question will be given to you. So how the question will be given, if you will see, that question will provide you with certain statutory provision which will give power to any decision maker. Fine. That decision maker, while exercising that power, has given a decision against your client, and while giving that particular decision, while exercising that power, he has not taken regard of certain procedural aspects, like right to be heard was not given, biasness might be triggered, fine, or he may have not given regard to, or when the interpretation is given by that particular decision maker, then in that interpretation he has made some error. So such interpretation should not at all be given. Like take an example of Vavilov case, where if we will see what they have done. So the minister or that immigration officer, he gave an interpretation of their own statute which says that delegates, the interpretation of word delegates were to be done, and delegates or employees of the foreign governments. So general rule is that whoever take birth in Canada, inland in Canada, he will be the citizen of Canada. But there are certain exceptions to it. So one of the exceptions was when there are delegates who are of the foreign country, let's say ambassadors and all, those delegates who are of foreign country, if they while living here, they give birth to any child, then in that case, what will be the status of that child, whether he will be Canadian citizen or the citizen of that country of which they are delegate. So that is exception, that they will be not considered as children of or they will be not considered as Canadian citizens. Now the question was, there were one couple who were Russian spy, and they were living in Canada, and they gave birth to Vavilov, and then they moved to America and they got caught there, and then they admitted that they were spying, and then they were released and sent back to Russia. Now the question was, till 13 years of age, Vavilov was Canadian citizen, and later his passport was cancelled. By saying that he was an employee, their parents, while they were living in Canada, they were employee of the Russian government. So accordingly, they said that he does not have that status of Canadian citizen. So this was challenged. So the statute interpretation was done in such a way. So particular provision was interpreted. So this is how the flaws are done by the decision makers, by the administrative decision maker. And this is how the court will look into. So we will be doing that in detail later. But as I was telling you, that a statute has given power to them, to the decision maker. They are making a decision, they are giving a decision because of that statutory power. Now the facts will be given to you, where they will be providing you with statute, and along with that statute they will be providing a person who has been impacted by the decision of the decision maker. Now you, as a lawyer, as an advocate, or as a articling student, we can say, mostly they give this way, that you are an articling student in a renowned law firm. So as an articling student, if you will say, what will be your analysis on this? So we have to analyze stepwise. So first step, as I have told you, is availability of judicial review, where we will analyze that whether judicial review is available. If we find that there is a judicial review, availability of judicial review is there, and there is a procedural issue there in that particular case, then we will move on to the second step, that what are the source, what sources are there which we will be triggering, which will be giving us answer to what procedure they have not followed. What sources we look in. So those sources are to be analyzed. That this source is there, these are the available sources. From these available sources we will be taking out which will be applied. Like if we, few example, if you will see, let's say a governing statute is there. So that if in the statute they have said that there will be a right to heard will be given, or statement should be taken from an individual against whom the decision is in, or against whom the tribunal is acting, or that decision maker is acting. His statement is mandatory. Now that means that statute is providing, and if he has not taken any statement from that particular person against whom the decision is given by the decision maker, that means he has violated his own statute. So procedure is not followed. The matter will be remitted back to the decision maker, and will be asked that by the court who is judicially reviewing it. They will say that your statute says that you have to take a statement and you have not taken a statement. First take a statement, then decide on this. Whether or not your decision will change or not, that is a different thing. But you need to follow a proper procedure which is being provided in your own statute. Are you getting the point? So that is an example, one of the example, governing statute. That is what we have to see as a source. If that statute is silent, then we'll see into other, like policies are there. Some guidelines are being present there or not. So if guidelines are present, again, guidelines say that there you have to take a statement. But you have not taken a statement, or that, decision maker has not taken a statement. And that guideline says that they have to take a statement of the person against whom they have to give a decision. So that is again a procedural flaw that has to be seen. Excuse me. So there will be a fundamental flaw again with regard to procedural respect. Then of course court will say you have, your guidelines say that you have to follow this, but you have not followed, will remit the matter back to you. Decide after taking a statement. So procedure is to be followed. If after procedure same outcome is there, still we are not concerned with that, but you have to follow the statement. You have to follow the procedure. It can be those guidelines which will be telling us. So we will be looking into different procedural aspect. So, or we can say we'll be looking into different sources that is there, they are present. So those sources will be looked upon, which will be triggering, which we will trigger. So those sources are very important, and that is accordingly we will see. Then there is a level of procedural fairness, if you will see. So we have to analyze, as is given in Baker case, that what level of procedural fairness is required. So we will be analyzing those levels of procedural fairness. And accordingly, after those analyzing those things which are being given from the facts, let's take an example of expectation. If you will see, there is an expectation that a person will be investigator should take the statement of the person against whom the decision is to be given. But there was no statement taken. So it has triggered an expectation, or we can say legitimate expectation has been breached. So it will trigger legitimate expectation, and we will say that high level of procedural fairness is required in certain cases, in these type of cases, or in this particular case in hand, or in question in hand, this is one of the breach. So this way we will analyze. So nature of question at issue, that is what we will be looking into. Fine. What procedure has been followed, that is what we will be looking at this particular point. So there are many, 5 there are, and we will be analyzing one by one, and accordingly we will be going. Then finally we will be analyzing the content of procedural fairness. What are the procedural obligations that are not followed by the decision maker? And then one by one we will be analyzing that which one is present, and we will be giving emphasis on that this is what he has not done, and accordingly we will conclude that this is how the decision is to be taken. This is the remedy that should be given by the decision maker, by the court, that it should be remitted back to the decision maker, and they will be deciding again based on the benefits which they can get from the analysis of the court. So those benefits which are there from the court decision, that these are the things that you have not done, you have to follow this. You have failed in providing fairness to a person, to an individual against whom you have given a decision. So the procedural fairness is required here, and that has to be done. That has to be sent back. That particular decision has to be sent back. So this is how we have to understand. Okay, is that clear? So this is it. I believe you have an idea of how administrative law is. It is a subset of constitution law. So administrative law is a part of constitution law, we can say like that, because in that sense there is a judicial review in constitution law. Here also we are doing judicial review. And if we will understand further, we have to analyze in certain cases, we have to analyze the constitutional, by the decision maker's decision, certain constitution provisions are breached. Let's say charter rights are breached. So then also we have to analyze. Then there is a different framework that we have to analyze. There, reasonableness is the review. Presumptive standard is reasonableness. Again, then we have to analyze in a different way that how those particular decisions can be analyzed, can be seen. Fine. What will court look into in case of when there is a decision given by the decision maker and that decision infringe any charter right of that particular person against whom the decision has been given. So that we will be understanding in our regular classes in detail. And these all are these are the briefs of what I have to explain. And otherwise, if we will look into my notes are very streamlined notes. They are explaining the things, and all that you have to write, you will be understanding all that you have to understand or you have to write. Fine. With regard to that, the question that has been given to you, you can find that particular aspect in my notes. And there are, if you will understand this, that the notes are being specifically mentioning step by step, in a step by step fashion, that this is how we have to go. Like I can give you some example of I can show you the notes, although they are in like this: availability of judicial review, step 1. Then we have to go source, of judicial review. There also you can see issue. Are you able to see issue, rule, and then application, and then conclusion in the next page? Here, conclusion, and then level of procedural fairness. So that is issue, rule, application, and then again in a similar way. So this is how we have to understand the administrative law, and we will be having good understanding of administrative law. Fine. So that is there. So by the end of our this course, we will be having a better or good understanding of the administrative law, and we will be answering accordingly. Okay, so that is there.